battery in November 2010, for which he was sentenced to an 18-month community order. I have been provided with reports about Mr. Berry's constructive work whilst he's been held on remand. Stephen Thomas is also 47 years old. Apart from a driving offence in 2021, he has no previous convictions. Michelle Mills is 46. She has no previous convictions. I have been provided with a character reference for Miss Mills relating to the work that she has undertaken for the Shannon Trust whilst in custody. I also have details of her achievements whilst in prison on remand. The Sentencing Council has issued sentencing guidelines for the offences of possession of an imitation firearm with intent to cause fear of violence and guidelines for perverting the course of justice. There are no guidelines for conspiracy to murder, but it is agreed that the guidelines for attempted murder are suitable for the court to have regard to those when considering offences of conspiracy to murder. Turning to those attempted murder guidelines, I assess the culpability as category B, high culpability, because of the significant planning and premeditation. I'm not satisfied on the evidence that the offence was committed for financial gain. In terms of harm, I assess the offence as category 3. Although I do accept that Mr. Mills is struggling with the continuing impact of this offence, I am not satisfied that the evidence demonstrates that he has been caused serious psychological harm as the prosecution submitted. The sentencing guidelines recognise that some psychological harm is likely to be caused by being the victim of offences, and the starting points and the sentencing ranges in the sentencing guidelines reflect that. For a category B3 offence, the attempted murder guideline provides a starting point of 20 years imprisonment with a range of 15 to 25 years. Turning to the aggravating and mitigating factors of the offence, I do not treat Mr. Berry's previous convictions as significantly aggravating, but he does not have, therefore, available the mitigating effect of having no previous convictions, which is the case for Miss Mills. The offence was committed in Mr. Mills's home. For Mr. Berry, there are aggravating features of the use of an imitation firearm and balaclavas. For Miss Mills, she deleted messages and lied to the police in an effort to cover up the offence. Beyond those matters, there are no other aggravating factors that have not already been taken into account when categorising the offences on the sentencing guidelines. Mr. Berry and Miss Mills fall to be sentenced on the basis of the harm that they intended, which was to kill Mr. Mills. There is usually little mitigation to be found in the fact that the plan was not a very good one, that it was poorly executed, or the prospects of successfully carrying out were slim. Nevertheless, I accept that the court, in fixing the appropriate sentence in the guideline range, can have regard to these factors as matters relevant to harm to ensure that sentences across a range of offences in the category are proportionate. Turning to the imitation firearms offences, to which Mr. Berry and Mr. Thomas pleaded guilty, it is common ground that the offence falls in category A in terms of culpability because of the significant planning and conduct intended to maximise fear or distress, arising in this instance principally from the use of balaclavas. I am not satisfied on the evidence that Mr. Mills has been caused serious psychological harm by the imitation firearms offence. First, I'm not satisfied that the harm described by Mr. Mills, for the reasons I've said, reaches the level for this category on the sentencing guidelines. Second, but more importantly, this harm was caused by his learning of the conspiracy to kill him rather than the use of imitation firearms. I assess harm, therefore, at Category 3. Applying the guidelines for use of imitation firearm on that basis, the starting point is 2 years imprisonment with a range of 1 to 4 years. As to the aggravating and mitigating factors of this offence, it is an aggravating feature that the offending was part of a group activity in which Mr. Berry played a leading role. In mitigation, I am satisfied that there was an element of coercion or exploitation of Mr. Thomas by Mr. Berry. Finally, I turn to the guideline applicable to perverting the course of justice. Miss Mills' offence falls to be categorised as culpability A because of the seriousness of the underlying offence. Harm is Category 2. The deletion of the messages was, I am sure, done to destroy evidence of the conspiracy and not simply to hide her affair with Mr. Berry. The lies to the police had limited impact on the police investigation because of the speedy apprehension of Mr. Berry and Mr. Thomas and the subsequent retrieval and analysis of the messages on Mr. Berry's phone. There was therefore some impact on the administration of justice, but it was not overall serious. Applying the guidelines, therefore, the starting point is 2 years imprisonment with a range of 1 to 4 years. Pre-sentence reports have been prepared for each defendant. In his interviews with the probation service, Mr. Berry has sought to minimise his role and denies that he had any intention of killing Mr. Mills. He told the probation officer that the discussions between him and Miss Mills were directed simply to Mr. Mills getting hurt and beaten up, and that on the evening that he'd travelled to Canarth with the intention of hurting Mr. Mills and giving him a hiding. The fake suicide note that Mr. Berry had prepared and taken with him that night demonstrates that that was not the limit of the plan. Echoing Michelle Mills' evidence at trial, Mr. Berry told the probation officer that the discussion between the two of them of killing Mr. Mills was all fantasy. Mr. Berry reported in his interview that he'd been using cocaine and cannabis and had consumed alcohol on the evening of the attack on Mr. Mills. He said that he had done so for Dutch courage. Mr. Berry did question, during his interview, whether Michelle Mills had been playing mind games with him. Miss Mills' pre-sentence report concludes that she has almost no insight into her offending, minimises her actions, demonstrates no empathy, and regards herself as a victim. There is no remorse. The author of the report states that Miss Mills' involvement in the current offence is indicative of highly manipulative behaviour and demonstrates the lengths she's willing to go to in order to achieve her desired aims. Set against that, the pre-sentence report and a separate psychologist report do shed significant light on the difficult childhood and trauma experienced by Miss Mills. I accept the submission made by Miss Rees Casey that Miss Mills' background does perhaps explain the speed of the development and the intensity of the relationship with Mr. Berry. Finally, Mr. Thomas. I accept from the evidence at trial and from the pre-sentence report that has been prepared on him that, at the time of the offence, Mr. Thomas was struggling significantly with the bereavement following the suicide of his brother, and that he had mental health vulnerabilities. At this low point, he was particularly susceptible to being recruited by Mr. Berry. There was an element of false or misplaced bravado in the text messages exchanged between him and Mr. Berry, and indeed his willingness to get involved. He could and should have withdrawn from assisting Mr. Berry on the evening of the 20th of September 2025, as soon as it became apparent to him what Mr. Berry intended to do. Mr. Thomas bitterly regrets his actions and expressed his remorse in his meeting with the probation officer, which the officer considered to be genuine. He apologised to Mr. Mills in the meeting. There are 2 psychiatric reports for Mr. Berry. Mr. Berry has been diagnosed with complex post-traumatic stress disorder, but otherwise has no psychiatric issues or mental disorders. I have a report dated the 1st of October 2025 from a clinical psychologist who states that Miss Mills also has a diagnosis of complex post-traumatic stress disorder, PTSD, anxiety and depression. I have reminded myself of the Sentencing Council's overarching guidance: sentencing offenders with mental disorders, developmental disorders or neurological impairments. I do not consider that the diagnoses of either Mr. Berry or Miss Mills substantially affected their culpability at the time of the offending, and there is nothing in the reports that suggests that it did. The mental health issues of each defendant are, however, relevant matters to be taken into account for the purposes of mitigation. Although the probation officer has assessed both Mr. Berry and Miss Mills as presenting a high risk of serious harm to Mr. Mills, I am not satisfied that the criteria for the imposition of a life sentence or an extended sentence are met in the cases of Mr. Berry or Miss Mills. The prosecution does not submit that the evidence supports a finding of dangerousness for the purposes of the regime of extended or life sentences. Neither defendant has previous convictions for specified offences, and the current offending is linked to a very specific set of circumstances which are unlikely to materialise again. Any risk of serious harm that either defendant might present in the future can be adequately addressed under the terms of the determinate sentences that I will impose and the licence regime that will apply to them. Mr. Berry and Miss Mills are to be sentenced each for 2 offences. In fixing the appropriate sentences for these offences, I will treat the conspiracy offence as the lead offence and, applying the principle of totality, will fix a sentence that reflects the overall criminality and impose a concurrent sentence for the other offence. In respect of the imitation firearms offence, Mr. Berry and Mr. Thomas both pleaded guilty at the first Crown Court hearing. The law provides that they are therefore entitled to a 25% reduction on the sentence that otherwise would have been appropriate. The sentence I am about to impose will reflect that reduction. Geraint Berry and Michelle Mills will be liable to serve 2/3 of the sentences of imprisonment that I impose before being eligible for consideration for release by the parole board. The time that each defendant has spent on remand awaiting trial will automatically count towards the sentences I impose. Any relevant statutory surcharge will be added to the sentences, and I make the order for forfeiture sought by the prosecution in relation to the items seized in connection with the offences. Geraint Berry, stand up please. Together with Michelle Mills, you planned to kill Christopher Mills. You devised the plan and led its execution. You recruited Mr. Thomas to assist you, and that evening, whilst intoxicated, you equipped yourself with items that demonstrate that your intention was to kill Mr. Mills, probably by gassing him, and to make it appear to be a suicide. However incompetent that plan was in its formulation and execution, and however unlikely it was to be achieved, your intention was to kill. The steps you took in preparation to accomplish that aim were no fantasy. They were a chilling reality. Your plan was thwarted by the remarkable fortitude and courage of Christopher Mills, who fought you and your accomplice off. Your mental health issues do provide some limited mitigation, but you have demonstrated only limited insight. I have made a modest reduction of the sentence to reflect the fact that the plan to kill Mr. Mills was highly likely to have succeeded. highly unlikely to have succeeded. For conspiracy to murder, you will be sentenced to 19 years imprisonment. For the possession of an imitation firearm with intent to cause fear of violence, you will be sentenced to 18 months imprisonment. This will be served concurrently with the sentence for conspiracy to murder. You can sit down. Michelle Mills, stand up, please. Together with Geraint Berry, you planned to kill Christopher Mills. Geraint Berry may have been largely responsible for devising the method of killing your husband, but you had encouraged Geraint Berry to execute that plan. The evidence strongly suggests that in the weeks leading up to the attack, you cultivated and exploited Mr. Berry's animosity towards your husband and encouraged him to find a way to get rid of him, not as some fantasy, but in reality. From his text messages to you, you knew the chilling truth that Geraint Berry was on his way to Carnarth that night. After the plan failed, the speed with which you set about destroying the evidence of the messages you had exchanged with Geraint Berry shows that you knew very well that they would incriminate you. Your principal personal mitigation comes from your lack of previous convictions and your childhood trauma, but the aggravating factors in your case mean that your overall criminality is equal to that of Geraint Berry. For conspiracy to murder, you will be sentenced to 19 years imprisonment. For perverting the course of justice, you will be sentenced to 18 months imprisonment. This will be served concurrently with the sentence for conspiracy to murder. You can sit down. Stephen Thomas, stand up, please. You played a subordinate role to Geraint Berry in the use of an imitation firearm to cause Mr. Mills' fear of violence. You have no relevant previous convictions, and your personal circumstances at the time of the offence mitigate the sentence that would otherwise have been appropriate. You will be sentenced to 12 months imprisonment. It has not been suggested that the sentence for this offence should be suspended, but I am satisfied that the seriousness of the offence means that appropriate punishment can only be achieved by a sentence of immediate imprisonment. However, given the length of time that you have spent on remand, the effect of the sentence that I have imposed on you today will be that you will be released once the necessary formalities have been completed. Unless there are any points that need to be raised, that concludes the sentencing hearing. The defendants can now leave court.